It is a pleasure to welcome you to this presentation on the use of public money that'll be given by Angela Heath and Patrick Virgadamo. We designed this presentation some months ago, some actually years ago, so that we could assist GOSEP in making sure that all FEMA dollars were well spent in Louisiana, and we would never have to return any money to the federal government. We are happy that you are participating today, and I hope you understand that our boss, Michael J. Waggesback, who is the legislative auditor, he believes, as we do, as I'm sure you do, in transparency and accountability. My name is Jenifer Schaye, and I'm the general counsel for the Louisiana Legislative Auditor, and have had the pleasure of doing that for almost 25 years. We believe in this office that contracting on public bid situations, that the use of public dollars after the contracting, that the use of state dollars and federal dollars is incredibly important, as I said at the beginning, to our state. And we're happy to assist you in this. I have the utmost confidence in Angela and Patrick that they'll give you excellent presentations. But I also want you to know that we are open at all times to additional questions you may have as you proceed in your work. And so our number, so that you can call us at any time, is 225-339-3871. And we have real people who answer the phones and real people who talk to you. So again, congratulations on your public service. We hope that you will all strive, as we do, to be good stewards of the public funds of the state of Louisiana and of the United States.
Hello, my name is Angela Heath. I'm one of the attorneys at the Louisiana Legislative Auditor's Office, and this is Module 1 of the series that we've designed for GOSEP. This is the Introduction to Contracts and Cooperative Endeavor Agreements. As Ms. Jenifer Schaye, the General Counsel, just spoke to you about, we designed this contract to discuss the use of public dollars and public contracting. This first module is about the basics of contracting. So before we get into talking about public contracts, you need to know the basics, we thought. In general, though, overview of this whole program is going to be the do's and don'ts and use of public dollars and the role of public officials in the use of public dollars. The overlying thing that we want you to know throughout this series, though, is that when you're spending public dollars, you're kind of working in a trust with the public. It's not your money, it is the public's money. And so everything should be done out in the open in a transparent manner. Now, so the basics of contracting principles. What's a contract? A contract at its base form is a voluntarily, legally binding agreement between two or more people. If you think about your life, you are entering into contracts all the time. If you have a cell phone that has like a 2-year agreement to get, so you can get the new iPhone, right? And you pay over time, you have signed a contract. If you have a mortgage for a house, you've signed a lot of paperwork, I know, and that is a contract. The bank is giving you the money, you're agreeing to paying it back over time. Now, so when you're coming to contract law, there's certain terms that we use. And what we say is that a contract is a bargain for exchange. It has to be a promise that is made using words or implied from conduct or a combination of the two. What you notice that's not on there is the word in writing. Writing the contract is not required, but government contracts should be in writing just for the transparency, so the public is understanding what's going on. But public works contracts by law in the state of Louisiana must be. Public works contracts are contracts for the construction of buildings or anything permanently affixed to the ground. Now, what does implied from conduct mean? You might see in your work a case where you have an invoice for debris removal services. and you might see a check that was written by the public entity for that invoice, but you can't see any contract, and maybe a contract doesn't exist. Well, that would be, you could imply from the conduct here that debris was removed, an invoice was sent, and for those services it was paid for, that there is a contract for that debris removal services. Now, issues to consider. Contract law, what they're involved in is what promises between the parties can be enforced. Contract law is concerned with how the contract was formed, how to interpret the contract, how to make the parties perform or honor their promises, and what remedies would be appropriate given the situation. So, if you have a contract with someone and everything goes fine, the courts don't get involved. Contract law is not necessary. You say, I'm going to do something for a certain amount of dollars, you do that thing, the person pays you, everything's fine. I had a law professor in college. He was representing a big ship dealer, and he was buying a big vessel, which are very expensive, and he had to sign a ton of paperwork for it, just like you do with a mortgage. And the man said, I don't know why you're making me sign all this paper. If I have the money, I'm going to pay. If I don't have the money, I'm not going to pay, right? So that's when the courts get involved, when something goes wrong. So what in public contracts, what I want you to know is that some state contracts should always include a mechanism to resolve disputes. There should be some language in there about how disputes are going to be resolved, how to terminate for convenience, and a non-appropriation clause. A non-appropriation clause is something required in Louisiana that says that if the legislature does not appropriate us money, if it's a multi-year type contract especially, we can get out of this contract without a penalty. So those are things that always have to be in state contracts. Now, the basic elements of a contract are an offer, an acceptance, and consideration. Now, an offer is defined as the proposal to contract. They call it the spark of the contract, the willingness to be bound. So a solicitation of bids, when you're going out for bid, that is kind of like you're asking people to make an offer. Are you willing to sell me these certain items? And so acceptance now is the next thing. And that is the agreement to be bound. Yes, I am willing to send you provide you these items. Now, what's consideration? Consideration means something of value. It's usually money. But definition is not, it doesn't always have to be money. It can be services in kind, for example, but it has to be reciprocal obligation that makes the contract enforceable. If it is a gift, that is not a contract. That's not consideration. So that's why you want to distinguish with what a gift is and what a contract is. That's what makes the difference. The reciprocal obligation. I will give you this much dollars if you do this job, or if you provide these services. So again, getting into some of the unique definitions when it comes to contract law. The person who makes the offer is called the offeror. The person who accepts the offer is the offeree. Now, the offer is what the offerer is, words or conduct that the offerer does that indicates to someone else his intention to enter into a contract. That sounds very complicated to say, for example, to the guy who cuts lawns in the neighborhood, will you cut my lawn for $50? That's the offer, right? Acceptance has to be voluntary, but obviously it's a yes or no answer. Once he says yes, then the acceptance is legal, as long as it's voluntary. You can't have a gun to somebody's head and force them into it. Now, again, like I said, consideration, that's the motivation element in the contract that makes the other person act. Usually it's money, but it has to be, again, voluntary in exchange of performances and a promise to one another of something of value. Your services, mowing the lawn, is something of value to me. The money I'm going to pay you for doing that is value to you. Now, what is very important is that you have to have these terms be sufficiently definite or certain. So you've got your offer, you've got your acceptance. Now you have to define the terms of the contract. And I would recommend, for example, that this is the point that things should definitely be going down into writing, whether you're a public entity or a private entity. This is the point where you want to define your terms in writing so they're very clear and everyone can understand what you are contracting for. If there's a dispute, how do you determine if the terms that you've written are definite or certain? That's when you go to general contracting principles. And what the courts have said is that the meaning of clear means there's a meeting of the minds that can't be vague. Both people understood what they were contracting for in this contract. There is a case that happened recently here in Baton Rouge called the LSU Health Parks Sciences Park versus the Swaggart Family Worship Center. What happened in that case was the Swaggart Family Worship Center had a big piece of property that they were trying to sell. LSU was interested, Health Sciences was interested in buying that property for an expansion. But they were not 100% certain that they wanted to buy it. So what they did is they entered into an agreement to purchase the land for X amount of dollars per acre, an option to buy. Like they were going to pay $100,000 up front for 1 year option to buy. So that's something of value, right? We're going to buy it for this. We might buy it for this price in a year. What we want you to do is we'll give you $150,000 now to take it off the market, not sell it to somebody else. Hold it for us. So Family Worship Center agreed. Then they extended LSU after a year was coming up. They still didn't know for sure if they wanted to buy it. So they paid an additional, the parties agreed to an additional $100,000 for another 1 year option to buy. Then 2005, August, Katrina happened. What happened to the value of land here in Baton Rouge? Prices soared. So the X amount of dollars that was in the option to buy was now very low. And in the option to buy, what had said from the beginning was the land survey would occur once they decide, LSU had said yes, they were going to buy the land. So there was no survey of what land was actually being purchased. Well, the first thing LSU did was go to the recorder of mortgages, file their option, file a survey that they had done and said, we are buying this land, this many acres, this design on the survey from the Family Worship Center for X amount of dollars. Well, Family Worship Center said, wait a minute, that's not what we agreed to sell you. They said that what they had agreed to sell was smaller than what LSU was saying they had agreed to purchase. So it went up and down the courts very many times, a lot of motions up to the First Circuit, back down to the trial court. Eventually, in the end, it took several years of litigation. The court came to the conclusion that the two parties had not really had a clear meeting of the mind. There was really a factual dispute of what was being sold. So that's an example of how a dispute will go to court over whether the terms are sufficiently definite to contract. Now, you also have to look and see whether a communication is really an offer or simply a preliminary negotiations. Now, this is always a question of fact. I kind of think that when you sell a house, when you put your house on the market, that's kind of really your opening negotiation, because usually they come back with a counter offer and you negotiate down. But in other countries, especially, there's a lot of negotiation expected. In the United States, that's not so much of a question, except for car dealerships. You know, you go into a car dealership, that sticker price, that's really kind of a jumping point. You can make an offer. You can walk in there and say, you know, car for sale, $50,000. You can walk in and say, yeah, I want this car, but I'm only going to give you 40 for it. And you can negotiate from there. So it's, like I said, it's always a question of fact. It's and so there's no bright line to tell whether it's an opening the opening price is a negotiation tactic, a start of a negotiation, or whether it is an actual offer. Now, there's a difference when you're going to look at contract terms between subjective intent and objective intent. Now, subjective intent is what the actual but unexpressed real intention of the party was, what that person actually believed they were contracting for. And there's the objective intent. And that is what a reasonable person would, from the outside looking at the situation, would think was going on here. And contract law is concerned what the reasonable expectations are, not what the true subjective intent was. Say I have a Lamborghini and I drive up and a guy loves the car, says, "Oh my gosh, I love my car. I will give you my entire life savings, $20,000 for that car." And I say, "Oh yeah, right. You can buy my car for $20,000. Maybe the guy really took me at my word. I was maybe obviously being sarcastic. I'm not going to sell a $120,000 car for $20,000, but he could truly believe that I was agreeing to that offer, that I would sell my car for $20,000. The court's not going to be concerned with that. The court's going to be concerned what a reasonable person looking at the situation from the outside would believe. There is a very famous example of this. It's the case called the Leonard versus Pepsi case. And they actually even have a Netflix documentary on it. And this was, Pepsi was selling Pepsi points, and you could buy Pepsis, collect the bottle caps. They were worth a certain amount of points. You could also pay money to buy points to redeem prizes. And so it was a big campaign, and Pepsi company did this commercial with a kid in high school driving a Harrier jet, which is a multi-million-dollar fighter type plane, to school that he bought with his Pepsi points. And, when the kid lands, the principal's toupee comes flying off and some other, so it was a humorous commercial. And the kid with like a real sarcastic grin at the end says, beats driving. And then they had flashed on the bottom of the screen, Harrier jet, 7 million Pepsi points. Well, a 21-year-old student, last name Leonard, said, "I'm going to get that Harrier jet." What he did is he got backers to give him $700,000, investors to give him $700,000, and he put some of the points that was in accord with the contest rules. He sent it in. Here's my $700,000. Here's my 10, bottle caps and Pepsi points. Give me my $7 million jet. And Pepsi said, no, it was a joke. They had to go to court. Eventually, the court did rule that based on the whole circumstances of the commercial, that no one really took it seriously, that no reasonable person would seriously think they could buy this military plane worth like $33 million for 7 million Pepsi points. I mean, some legal people will actually say, the way it was presented, that Leonard had a good point, but that is how it went down using the reasonable person standard. Pepsi did not stop running the commercial, but they did make the points a lot higher to where it would have been. They went from 7 million to like 7 billion or something Pepsi points. They did something, they adjusted it to where it would have been basically the cost of the jet to get it. To be able to buy it. Anyway, so that's a reasonable expectations. The court ruled no reasonable person looking at that commercial, given the whole circumstances and the humor in the commercial, that you could actually buy the Harrier jet for 7 million Pepsi points. Now, the certainty of terms. What terms have to be in the contract? You have got to have who the parties are. Who are the parties? The price, although in some cases, price can be determined later. When you're buying something like fuel, that's a volatile item, you might buy it on a price index and not the actual price. The subject matter, and the time for performance. So what are you going to do and when are you going to do it? Who's doing what, the price, the subject, what's getting done, and how long you have to do it, the time of performance. Those have to be certain terms. Now, the law, for public contracts, these things have to be in there. Now, the duration of the offer. So say you make an offer to someone to buy something, and how long do they have to respond to you? Well, as the offerer, you can put a time limit. Get back to me by Monday, whether yes or no, right? But if there is no intended, if it's not stated, then it's called a reasonable time, which is always a question of fact. So depending on what is going on, sometimes that reasonable time is longer than others. If I had tickets to next year's Super Bowl and I offered them to you to buy them, to sell them to you, well, that time's going to be a little bit longer than if I'm standing in front of the Superdome for the game that's going to start in a few hours selling my tickets, right? The offer is only going to be a short amount of time until the game starts. So again, this is a question of fact that you have to determine, but the courts will look at what's reasonable given the circumstances. Now, what happens? So you have an offer. What's the next step? Well, the offeree can reject the offer. I said to the person, will you, the guy who cuts grass in my neighborhood, for example, will you mow my grass for $50? He can say, no, I've got too much work right now. I can't do it. Or he could have given me a counter offer. No, if your lawn's kind of bigger than everybody else's, I'll do it for $75. Or I could, as the offerer, revoke the offer. If I have given you time to get back to me on whether you're going to accept, I can rescind it before the acceptance date. So I can just come back to you, say, I agreed to sell you my car on Friday. And I say, please get back to me by next Wednesday. I'm really trying to sell it, but then something happens over the weekend and I decided I'm not going to sell it. I can come back to you on Monday, which is before Wednesday, and you still haven't accepted yet, and say, you know what, I've changed my mind. I'm going to keep my car. And you can't take me to court for that. Now, like I said, as the offerer, you have the power. The offerer creates the power of how acceptance can be. Not only the time, but any manner of how that and medium. So, you must send me a telegram accepting my offer. You can only accept my offer in writing, a hand delivery. You can do that. If you think about it with public contracting, electronic bids, having to submit by a certain date, those are part of the public contracting requirements, the manner of acceptance of the offer. So like I said, you can say, you've got to call me. You've got to tell me in person. Phone call, email. Nowadays, a lot of things take place electronically, so they're a lot faster. And it's kind of a given that with the fast amount of communication, but these were a lot more important back before electronics, the computer age. Now, the acceptance, the offer, unless restricted by the offer, can be accepted either by returning the promise or by making full performance of the requested act. So say to the guy who cuts grass, I want you to cut my grass. Will you do it for $50? He can say, yes, I will do it by $50. I'll put you down for every Tuesday. Or he can just start cutting the grass without saying a word to me. By doing what I have, performing the service I have requested of him, he has accepted my offer. And so now I do owe him that $50. I can't get out of it. Now, the offer is entitled to notice that the offer is accepted the offer unless notice has been dispensed with by the offerer. Now, nowadays it's more instantaneous. Before, it could have to be, as I said, with the email, but you can actually request a formal notice of acceptance. What would happen in older days, if you're going to accept this offer, you must send me a wire by such and such date, and then the actual acceptance would come later in the mail. And again, how it's communicated, again, more important prior to instantaneous communications. They used to have like a mailbox rule. You accepted the offer and it was postmarked by a certain date. That met the time limits of when you had to accept the offer. Fax, but you can do hand delivery, email. And again, if you are the offerer, you can dictate the terms of the acceptance. So with that out of the way, the basics, I also want to talk to you today about cooperative endeavor agreements, or CEAs. This is something that is very common that you'll see when you're dealing with public entities, especially if they're contracting with other public entities, but also with private entities as well. And we're going to talk about Article 7, Section 14 of the Louisiana Constitution and the Cabela's test, because these are very important things to know about when you're dealing with cooperative endeavor agreements. Now, what Article 7, Section 14 of the Louisiana Constitution says, basically, is that you have to spend public money, you have to get value back for what you're spending when you're dealing with public funds. Like, spend the money wisely is the summary, and also you cannot donate public money. Now, when you are entering into the most usual type of contracts for governmental services or materials and supplies, it's obvious whether you are getting good value for your public dollars. You're buying a car, say a vehicle, a work truck, for $70,000. Blue Book value is $70,000. Everyone can see you spent a reasonable price for that truck. But there are other types of contracts where it's not as clear of what the public entity is getting in return for the expenditure. And that is when cooperative endeavor agreements are needed. And what the cooperative endeavor agreement is going to show that what the government is getting with this money, they have the legal authority to pursue the entity, that expenditure as a whole is not gratuitous, and there is a reasonable expectation of public benefit of equal or greater value in for the expenditure of the public resources coming back to the governmental entity. This elements came from a case that's called the Cabela's case. It's not even really the name of the case, but it involved the building of the Cabela's store on I-10 in Gonzales. And what was at dispute in that case was a TIF arrangement, tax increment financing, where the city had agreed for economic development purposes to waive some of the front end taxes for Cabela's Corporation. And they said when they were taken to court, they said that they couldn't do that because they were giving up public funds, that what they expected to receive back over time was the tax dollars that would come in through the payroll taxes and through people actually going there to buy goods. They would be paying sales taxes. People would move there to be close by, to work there. And eventually it went up to the Louisiana Supreme Court. And that's when these elements were developed of these type of contracts where you can't really see what the benefit coming back to the governmental agency is, like you can with other goods and services. So these are the things that would be clearly written in the cooperative endeavor agreement for these types of transactions that would show what the government really has a reasonable expectation of getting back for the spending of these public dollars. And it's got to be at least equal to the amount that they're spending. So again, legal authority. You're showing in this cooperative endeavor agreement, I have the legal authority to pursue this action. A city, for example, does have a legal authority to pursue economic development. They might not have legal authority for other things, but for economic development, they would. It has to have a public purpose, can't be gratuitous, has to have a real public benefit or the expectation of public benefit. And there has to be reciprocal obligations. Whatever the public entity is doing, the other party to that CEA is also doing something in exchange. It's recommended to be in writing. You will find entities that one parish is supplying water to the other parish, or one town that's bigger is supplying the water to another smaller town, more rural town, and they're getting paid for it, and it's been going on like that for 50 years. And it's not in writing. That's basically what they've entered into, is a cooperative endeavor agreement, but it's not in writing. It should be in writing, okay? Now, CEAs that are authorized under the local services law, the Attorney General has said must be in writing. So at least there's one that has to be in writing, but we would recommend that they're always in writing. Now, some things to keep in mind. Government cannot donate public resources even for a worthy cause. It can be the St. Jude's Hospital saving little children with cancer. Cannot use public funds. That's something they don't have the legal authority. The city of Baton Rouge was not incorporated to give to charities, even such a worthy cause. Just because you write a cooperative endeavor agreement, so just because a cooperative endeavor agreement exists doesn't mean the transaction is actually legal. So you still have to look and see if all those elements are met. A cooperative endeavor agreement should not be written in such a way that it actually makes things more complex or clouded. It should be written in a clear manner so that the people can see what is going on with this agreement. Like I said, they don't have to be written, except in the case where the Attorney General has said so, but they should be, if they're not written, it would be suspicious. Now, there is a certain revised statute that authorizes the donation of equipment and personnel between public entities using a cooperative endeavor agreement. This requirement it requires a CEA to be entered into. And if you're looking for sample CEA language, you can look at the Louisiana Legislative Auditor's website. We have what we call an FAQ on cooperative endeavor agreements, and we include a sample CEA. I will tell you that sample CEA is covering all scenarios, so it probably has a lot more things in there than not every CEA is going to need everything that's in that sample. That's why it's just a template or a sample. Now, this Article 7, Section 14B authorizes the use, so the donation for the use of public equipment and personnel by a political subdivision to another political subdivision. The Attorney General has said in Article 20, Attorney General Opinion 20-0099, that the key word here is use, not transfer of the equipment. So if the parish wants to lend some big piece of heavy equipment that it happens to own to the levy district for a specific job, they can do that. It cannot be that the parish is just giving that big piece of equipment to the levy district. Now, the CEA should cover, why, how long they're going to have it, what the job is for, who's going to be carrying insurance, who's going to be responsible for any kind of damage to the equipment or damage to anybody using that equipment. Those kind of things should all be in the CEA, but they cannot just be buying or just giving that piece of a heavy equipment to the levy. It has to just be for use. You will see a lot, I think, in GOSEP, that you will see these compacts for emergency situations that are pre-written, like they have the interstate mutual aid, that's parish to parish, the EMAC, which is the national one, it's state to state. After Katrina, there was I'm sorry, not after Katrina, after Hurricane Sandy in New Jersey, people from Louisiana, emergency personnel from Louisiana went up there to Sandy to help out. That's because having these kind of cooperative endeavor agreements, they call them compacts, but they're very similar cooperative endeavor agreements for emergency situations in place beforehand, makes it easier and faster to respond to the situation, to lend personnel lend equipment and services to other places that need it during after a hurricane, et cetera, without violating the Louisiana Constitution. And other states obviously have similar things. So you put those things in place. Another thing I want to put out is that let you all know that the Constitution of Louisiana does allow donations of public safety entities to one another of public safety equipment. So you will often see a sheriff give radios to police departments in the municipalities within the parish. And the idea is that way they can communicate easier with the sheriff and respond to emergency situations faster. So I know I've been telling you can't donate things. There is one real donation that can happen. It's only public service entities to other public service entities of public safety equipment. So that is an exception. Now, this is the website that is of the Louisiana Legislative Auditor. It's www.lla.la.gov. You can go in up to resources when you scroll on there and go down to legal assistance. And on that page is where you're going to be able to find what we call the FAQs, where we have written up things on public bid, CEAs, all different types of public laws that are in a question and answer format. And hopefully that'll be helpful to you. Now, Patrick Vergadamo is going to be here in one of the modules on the Louisiana Procurement Code and on FEMA procurement. I am going to be with you for the public bid law, the Louisiana public bid law, but here is our number where we can be reached if you have any questions in the meantime. So thank you very much.